And welcome to the Joint Committee on Administrative Rules and Regulations. This is a new calendar year and a new legislative session. So this being a joint committee, the Senate and the House alternate who is the chair, vice chair, and ranking minority member of the committee. And so this year it is the Senate. And we thank Vice Chair Wassinger for her chair leadership last session and last year. And so we've switched seats, and we do have a new ranking minority member as well, Senator Faust Godot. So we do have several members joining us on WebEx this morning. So we do, for the purposes of this joint committee, have a quorum, and want to welcome staff who help keep the train running on time, and we wouldn't be here and able to do our work without them. So thank you all. And welcome to the members of the committee. And our first order of business is approval of the minutes of the November 27th, 2023 meeting. Do I have a motion?
Madam Chair.
Madam Chair, I move that we approve the minutes as written for January. No, I'm sorry. I don't see the date. Yes. November 27th, 2023.
Thank you. Do we have a second from anyone on WebEx?
Senator Marcy Francisco, I would second. I've read them.
Senator. We have a second then, and with that then, you all have heard the motion. All those in favor signify by saying aye.
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 Those same sign. The motion passes. With that then, we will then proceed to our first, our second item of business on the agenda, and that is State Board of Regents. And we do have first then brief remarks from Blake Flanders, President and CEO. Please introduce yourself and welcome to committee.
Good morning, Chair Warren and Vice Chair Wassinger. My name is Blake Flanders. I'm the President and CEO of the Kansas Board of Regents. And today we are here for discussion of the and feedback of the regs for the Adult Learner Grant Program. This was a statute passed last year, a new state scholarship for up to $3,000 a semester for eligible students. Within the statute, there was a requirement to pass regs or develop regs in 6 areas. The definition, application, appeal procedure, scholarship terms and conditions, which actually just repeats the language in the statute, conditions of postponement or release, and repayment. And so with that, we've this is part of our process. We've developed those regs through the Department of Administration and the Attorney General, and we're here to get feedback in those areas.
Thank you. Committee, any questions? Yes, Representative Wassinger.
Thank you, Madam Chair. Mr. Flanders, do any adult learners or come from private universities?
Yes.
As well? So it's open to all students that are in higher education?
Absolutely.
All right. Thank you very much. Thank you, Madam Chair.
Thank you. Any other questions? Seeing none, then thank you very much for appearing in committee today and updating us.
Okay, thank you.
And then next we will have a briefing and presentation of the rules and regulations before us today from the State Board of Regents, presented by Gage Rolfe, Associate General Counsel. But no, you have more remarks.
I have Gage here, and I may just call him up. We have some revocations here.
Okay, we just got, as committee members, proposed revocations from the Board of Regents yesterday, and we are going to then first hear about the proposed revocations of rules and regulations from Gage Rolfe, who is the Associate General Counsel for the State Board of Regents. Please introduce yourself and welcome to committee.
Good morning. Thank you, Madam Chair. I am Gage Rolfe. I'm Associate General Counsel for the Board of Regents. I guess we're taking the revocations first. Beginning in 2023, KSA 77-440 requires agencies to review their existing regulations every 5 years.
Is your microphone on?
It looks like it is. Do I have it aimed incorrectly?
Right. Everyone online also needs to hear you as well. Thank you.
Anyway, by statute, beginning in 2023, there's this 5-year review that agencies are to undertake of all of their existing regulations and to identify regulations that are no longer necessary. Under state law, the board's first review is due in 2026. We've begun that process, and we've already identified these 23 regulations that pertain to various student financial aid programs that are now obsolete. We don't believe that they serve any further purpose, and we are seeking to revoke them. I can go through each of the various programs if you'd like and explain why the regs are obsolete. Or
I think if you just want to let those who are following along, just the subject of there's a couple articles here that have some revocations in them. If you just want to go through the subject area of those articles, just to state what they are so that those following along online can see that as well.
certainly, Article 7 involves what was known as the Student Assistance Program. Those regulations date back to 1975. The regulations that we seek to revoke contain requirements that have been superseded by federal law on student privacy and tax return information. Sorry, that was Article 13.
I was going to say, I don't see Article 7.
I'm getting cranked up here. I'm sorry. So that's Article 13. Article 14 involves the Community Resource Program. That was an older program that's no longer funded and no longer carried out. So those regulations are no longer necessary. Okay. Article 18 involves the Kansas Honors Program. Again, that's a program that's no longer funded or utilized. Article 20 is the Kansas Nursing Student Scholarship. That is a current program. We're seeking to revoke an outdated cap on scholarship amounts that dates back to the 1990s, and again, outdated and requirements on confidentiality of information that have been superseded by federal law. Article 21 is the Kansas Ethnic Minority Scholarship Program. These regulations also date back to the 1990s, and again, they're superseded regulations regarding privacy. And then there is also an outdated regulation regarding the distribution of scholarship funds when the program's oversubscribed. Article 22 is the Teacher Service Scholarship Program, another outdated confidentiality regulation. Article 27 is the Washburn University Out-District Tuition Act. Those statutes expired in 2006.
Thank you. I have just one question. A lot of the articles that you discussed and the revocations you had mentioned were superseded by other law or regulations.
Sure.
Regard confidentiality of information. So the information is still kept confidential. It's just regulated or governed by statute that supersedes what you're revoking.
That's exactly right. The information pertains to regulations. Pertain to information that's now contained on students' FAFSA forms, and the privacy of that information is covered by the Federal Family Education Rights and Privacy Act, as well as the FAFSA statutes.
Okay, thank you. Committee, any questions? I'm not seeing any. Yes, Representative Wassinger.
Just a quick question. I know that we've asked you to go over and go over a lot of different articles within what you've had in your rules and regs. What kind of percentage would this be of your entire body of rules and regs?
I would. You mean the number of regulations that we're talking about today, the 23? It would be a wild guess, but I would hazard to say maybe 5 to 10%.
Okay. Are you continuing to go through regulations to find out what else needs to be revoked?
That's correct. Yeah. So our list is due to the committee in 2026, and these revocations sprung out of a review that was only done by our student financial aid staff. And so we have several other areas that, that the board works with.
That's great. Thank you, Madam Chair.
Thank you. Committee, any other questions?
Madam Chair, Rep. Penn,
I'm sorry?
Rep. Penn, can you hear me?
Yes, go ahead, Representative.
Thank you, ma'am. Is these regulations, the revocation of them, is there a price tag associated with it, either to in cost savings or efficiencies? What does that landscape look like?
No, sir. In our economic impact statement, we estimated a $0 impact. It is neither a negative nor a positive impact.
Thank you, Madam Chair.
Thank you. Committee, any other questions? Not seeing any, then go ahead and proceed. Thank you.
Well, that concluded my presentation on the revocations.
Sure, if you want to go ahead and proceed with the proposed regulations today.
On the Adult Learner Grant Act, is that what we're going backwards?
That is what's up next.
Wonderful. Okay. Well, as President Flanders said, the Act directed the board to adopt regulations in several defined areas. Those were grant application, renewal forms and deadlines, appeal procedures for grant denial or revocation, grant terms, conditions, and requirements, procedures for requesting and approving recipients' absence from their institutions while receiving the grant. In addition, the Act also suggests that the board should adopt regulations concerning what constitutes good cause to postpone requirements of the grant agreement and regulations governing grant repayment upon breach. And so working through the regulations we've proposed, there are 6 of them, as President Flanders said. The first just sets out definitions that apply throughout the regulations. The second requires students to submit initial and renewal applications each academic year and to do so by deadlines established by the board president and CEO. And the applications must be on forms published by the board. The third regulation permits applicants to appeal grant denial or revocation through their students' financial aids offices. And the regulation also establishes minimum appeal procedures, and those include the processing time for the appeals and evidentiary and other standards that the decision on the appeal must meet. Fourth, establishes scholarship terms and conditions. As President Flanders mentioned, that regulation keys directly back to the requirements set out in the Act. The fifth establishes conditions under which an agreement's requirements may be postponed. It also requires the board to coordinate with the student's institution if a request for postponement would coincide with the student's absence from the institution while receiving the grant. And then the sixth and final regulation establishes repayment requirements, and it would require repayment of a scholarship upon breach of an agreement to be made over a 5-year period or within 5 years from the date of the breach.
Thank you. Committee, are there questions? I don't see any on WebEx, but if you could hold on just a moment, please. We're going to hold just a moment, please.
I do have a question. I know that she will allow me to. So thank you, Madam Chair. Now, are these replacing all the regulations that you revoked? I mean, it looks very similar in the lineup.
No, We're required by the Adult Learner Grant Act, which was enacted last session, to implement these regulations, and these regulations would only apply to that act.
Okay.
Yep.
All right. Thank you very much.
Thank you. And I just wanted to take a moment to bring Senator Tyson up to date, who has joined us as far as where we are in our agenda. So thank you, committee, and those following along for standing at ease for a moment. And we do have a question from Senator Faust Godot.
Thank you, Madam Chair. I just wanted to know, I thought I heard on the Senate floor yesterday that the meeting started at 8:30. So did it in fact start at 8?
It did, yes. I hope I was clear and stated that it started at 8 yesterday on the
Oh,
Senate floor. I think I
well,
did,
I'm,
but
it's so funny. I thought, oh, I'll get on early, and but I'm glad I'm here. Thank you.
well, no problem, Senator. We're glad you're joining us as well. So, with that, committee, are there any questions? I'm not seeing any. So, thank you very much for your presentation today. Are there, I don't see any other regulations, but we do have a question here. Thank you, Senator Tyson.
I do, and thank you, Madam Chairman. I apologize, but one of the changes that I was reading through last night, you're changing the licensure so that they have to just be, if they plead guilty or if they negotiate, or you're not saying a conviction, that it was proved without a doubt. And I know some people will plead under fear or
I apologize. I believe those are the regulations that the State Board of Education will be
Oh,
presenting
yes,
on the next
I'm
item.
sorry,
Yeah,
I thought
we,
you were-
we were a last minute addition to your agenda, I think.
Yes, sorry. I apologize. No, I'm really concerned about those. So whenever you get up here on that.
All right. Well,
thank you,
that's
Madam Chair. I'm sorry. I should have waited.
some questions coming up. But for you, sir, thank you very much for your testimony. We appreciate you being here.
And my pleasure. Thank you.
Thank you. With that, then, we will next hear from the State Board of Education and invite Mr. Scott Gordon, General Counsel, to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and other members of the committee. My name is Scott Gordon. I'm General Counsel to the Kansas State Department of Education. I have been General Counsel for almost 10 years now. I've worked with the agency since October of 2012, and when I was first hired by the Department of Education, my primary responsibility was investigating and prosecuting allegations of professional misconduct. So the regulations that are before you now are things that I've been working with and on for almost 12 years. In addition to my work as General Counsel with the agency, I would share that I'm on the steering committee for the NASTEC, that's the National Association of State Directors, Teacher Education and Credentialing. Hopefully I got that acronym right. The Professional Practices Institute, and there's been a special project for the past 2 years to come up with model legislation addressing grooming and other inappropriate behavior that unfortunately licensed professionals may engage in. That's not what I'm introducing to you today, but I just point that out that a lot of the language that I share with you has also been included in that model legislation, and it has been beat up all over the country for the past year. And there are several other states that I believe are going to be adopting a lot of the language that I'm presenting to you today. The regulations, and Madam Chair, if I may, without getting into the weeds of the regulations yet, just to kind of give an overview of the process. If my office receives an allegation of misconduct, whether that be based on someone's criminal conduct or whether it's just misconduct that someone observes in the classroom, then my office investigates and decides whether or not to move forward with a formal complaint. I will gather the information, I take it to our Director of Teacher Licensure generally, and he or she decides whether to sign that formal complaint. That complaint then goes to, they get notice of the complaint, they have the opportunity to file an answer and ask for a hearing. And if they do ask for a hearing, it is conducted before the Professional Practices Commission, which is a statutorily created entity. It is 9 educators throughout the state of Kansas at all levels, administrators, teachers, what have you, that are appointed by the State Board of Education. They take that work very seriously. They conduct the hearings. and they make recommendations. They write an initial order that goes to the State Board of Education. If either the complainant, which is usually my office, or the licensee or applicant, if they disagree with the recommendations of the Professional Practices Commission, then going before the State Board is essentially their opportunity to appeal. It's kind of a second bite at the apple, if you will. Ultimately, the State Board of Education makes the determination whether to issue the license or whether to discipline in either public censure, suspension, revocation, or denial. So that is kind of the umbrella approach that we take to the Professional Practice Commission. The only difference would be in cases where a teacher is in violation of a contract. And if the school district wants to file a complaint alleging that a teacher has, or an administrator has violated their contract, those complaints are investigated and prosecuted by the school districts, because that's a contractual issue between the school district and the teacher. My office does not. And we'll get into the weeds on a couple of the regulations on that, but that's really the only difference.
Would that then be with the school district and the teachers union, or if it's a contract issue?
So aside from it being the employment issue to start off with, right? Like, we're never involved in that. Many times I think a teachers union will represent the teacher that appears before the State Board and Professional Practices Commission. But we have it set in regulation. And I will tell you, over half the states, they have similar provisions that if you breach a contract, then your license very well will be suspended. And again, I'll get into this when I get to this particular regulation, but there is a specific remedy for breach of contract cases. And there's really not much discretion with the State Board. It's if the State Board finds that the educator is in violation of their contract, and there's not a buyout provision, that's a very important part of it, then the remedy is that license will be suspended through the remainder of that contract. So usually through the end of May, the middle of June, whatever the contract says.
And how long is a license needing to be renewed? Is a teacher's license good for 5 years? What's the duration?
Honestly, it depends on the type of license they have. Substitute licenses, I believe, have to be renewed every year. An initial license is every 2 or 3, or your initial license is for 2 or 3 years. Your professional license, once you reach that level, it's a 5-year renewal.
5 years. Okay, thank you. Please proceed.
So looking at 91.22.1A, you'll see that we actually, 22.1A and 1B essentially splits what was originally just in 22.1A. That was in response to KSA 74.120, whereby there's grounds by which the State Board may deny a license, which are different than the grounds by which the State Board may revoke, censure, or suspend a license that already exists. A lot of the language is really just clarifying what our actual practice has been for a number of years. Instead of just relying on the term conviction, because so many jurisdictions use different terminology, and to clarify so that everyone was aware, basically we put every means by which someone could be found guilty in a court of law, whether they plead it, whether they plead no contest, no contendere. Some states, they may find you guilty up front, but you don't serve a sentence. And if you complete the probation at the end of the probationary term, they no longer call it a conviction. I think Missouri has a lot of felony convictions that way. So we just want to clarify that if you are convicted, or if we prove the conduct, because we don't have to rely on criminal cases in a lot of these instances, then the State Board may take action for any crime that is a felony. Any crime involving a child under the age of 18, other than the accused as an element. That is to clarify, we're not looking at someone that was arrested for an MIP or a crime in which they're not allowed to have tobacco under a certain age. That's not what we're talking about. We're talking about if there's another child, specifically under the age of 18, that you have done something, and because that child is there, that may be an enhancement. For example, if you are convicted of a DUI and there's a child in the vehicle, that is a slightly different conviction than just DUI. And then any crime involving a theft or any crime involving drug-related conduct, that is not a change. That's the way it has always been. The crimes involving 21, basically Chapter 56, those are the child abuse. I call those are the child abuse and the child neglect, child endangerment cases. Attempt still counts if you're convicted of any of those things. The commission or omission of any act that injures the health or welfare of a minor, that's been that way for over 20 years. Engaging in any sexual activity, because we didn't want there to be any wiggle room or anyone to claim, well, that doesn't really, I didn't, we've actually had this argument come up that they were not exploiting the child, that the child voluntarily consented to it, which did not get that person very far, but it was an argument they made.
For purposes of your explanation, you said engaging in any sexual activity. You mean with a student?
Right.
Okay, because the way you were testifying, you left off the with a student. So
very important second clause of the sentence that I didn't read, and I apologize. Yes, it is specifically referring to 9122(1)(a). A3 is engaging in any sexual activity with a student. Yes. Thank you for having me clarify that. 4 is what I would refer to as our definition of grooming, and this is a language that has been vetted quite a bit. Engaging in any behavior that can reasonably be construed as involving an inappropriately and overly personal and intimate relationship with, conduct toward, or focus on a student. The purpose of that language is to not wait until the teacher has already engaged in a sexual relationship with a student. I can't tell you how many cases we have where staff know that something is going on or something is about to happen and they want to intervene and they feel like, well, we can't prove they actually had sex, but there's something wrong going on here. So that is our effort to try to clarify that. And I will tell you, if we are aware of that level of misconduct, we enter those complaints anyway. This is to put everyone on notice that this is what we're talking about.
is this language that is used in other states already?
This is the language that we have introduced as part of that model legislation I shared with you, and that other states are going to be using very similarly.
So it's not yet in law in other states.
Not that exact language.
And I'm going to pause just for a moment there for a question from Senator Tyson.
Chairman, and I've just heard this statement over and over again, and you're creating definitions through rules and regs. I just have so much concern over this. This should be through statute. This should not be through rules and regs. Thank you, Madam Chairman.
That's a point well taken. I think this is policy. This is defining in law inappropriate behavior. And we have a question then from Senator Faust Godot.
Thank you, Madam Chair. Sir, if when the allegation is made, is the educator still employed or are they relieved of duty prior or during the investigation? So what you just discussed, would they automatically be in this status, or are they allowed to have the due process prior?
Matt, if I understand your question correctly, nothing happens as far as the state board and their status as a licensee unless and until the state board bangs their gavel at the end of the process.
Okay.
If the teacher is still employed, and I would tell you 95% of the time, the teacher has already been either separated from employment or they have left the job by the time we are really investigating these cases. Not always, but most of the time. That's an employment issue that the department has nothing to do with, the board has nothing to do with. But yes, they are given all due process that is allowed under the law prior to we taking any right away from them as a licensee.
Thank you, Madam Chair.
When you say they are afforded all due process due under the law, what law are you referring to?
That's later in the regulation that explains the hearings and the Administrative Procedures Act.
That's okay. So not any, are you talking about, well, okay.
So hearings are conducted pursuant to the Kansas Administrative Procedures Act, which is set in statute. There are slight differences in just process that are clarified within the regulation. And the regulation does explain that here shortly. Madam Chair, if I may continue, or if there's more questions at this point, I don't.
Yeah, we have a question from Representative Wassinger.
Thank you, Madam Chair. And did you say you worked on these for 12 years? Is that what you?
No, I've worked for, pardon me, Madam Chair. I've worked for the department for almost 12 years.
Okay, so you weren't just working on this for 12 years.
No.
Okay, well, my question about the article that the item that you're talking about in number 4 of 91-22-1A, it says any behavior that can reasonably construed as inappropriate or overly personal or intimate relationship. What's the definition of reasonably? I mean, if does this allow someone who does not really like another teacher because they're very popular with their kids? Is that part of being reasonable, or is that more of a witch hunt? I mean, do you see what I'm trying to say?
I think I understand your question, the concern. And Madam Chair, if I may. Yes, we have received complaints from parents and other staff members that we have looked into. We've spoken to the would-be witnesses, the complaining parties. We speak to others and find out, okay, what's really going on here? And there are cases where we look at it and go, this is not what we consider to be a licensing issue. And then I share that with our director of teacher licensure, and we discuss it and decide not to file those cases. Say, no, that's not a licensing issue. The reason why we put that language in the reasonably construed is because someone may say, well, look, here's the problem with trying to stop grooming before it actually becomes a criminal thing. It is impossible to have an absolute bright line. It's just not there. You're never going to find it. I've tried. You're just not going to find it. That is why the person has the opportunity, if they are accused, they can come forward to the Professional Practices Commission and explain, look, the only reason I was giving this child a ride to and from school is because the child is essentially homeless. There's no one at home to get that child to and from the school. My family was in the car with me the entire time. There was nothing inappropriate about any of this. That's not a hypothetical. I've had that. The complaint was alleged. Someone brought up, said, well, you can't be driving kids back and forth to school in your personal vehicle. When you talk to others and find out what's actually going on, is it reasonable for a teacher to potentially, I don't want to obligate myself here. Are there circumstances where it's perfectly acceptable for a teacher to provide a ride to a student? Yes. Are there other circumstances that, given the nature of the timing of the rides, no. Is it appropriate for a teacher to pick up a 15-year-old student and drive her across state lines to go hang out with friends of his on weekend nights? I'm going to go with no. We filed that particular case, and I will tell you that because they were having sex in the church parking lot in Colorado. We would not have known those details if we hadn't looked into it. So I understand. I think I understand the concern, but no, there's no bright line definition of reasonably construed. That's going to be decided on a case-by-case basis. That's why we have the hearings.
Okay, and Madam Chair, just one more quick one in this. In order to, it looks like in order to submit a petition to the board for change of what's been they've been charged with, it says you have to have a check for $50 in order to file your appeal. Is this higher than you usually have? Are you changing the price on that?
Okay, that's getting to the next page, Madam Chair. If you like, I can jump to that part of it.
No, that's all right. You can answer it when I get there. I'm sorry.
Yes, let's please hold that question till we get there. And we do have a question from Representative Wagner.
Thank you, Madam Chairman. Hope you folks can hear me fine. I would like to ask the participant if how often does the state Board of Education or the Education Department, as it would be, have to deal with these types of complaints, just in general, as far as these inappropriate sexual contact? I mean, does this happen a dozen times a year, 100 times a year? How often is this going on in Kansas public schools?
Madam Chair, if I understood the question, I apologize, it was kind of cutting out. I believe the question is, how often does the Department of Education have to deal with allegations of sexual misconduct? Is that a fair summary of the question?
Yes, yeah, that's exactly right.
I will tell you that when this was my primary role, Unfortunately, I used to joke, I wonder what day of the week I'm going to get through before I hear of an allegation or there's some update on a case involving inappropriate relationships. Eventually it got to the point of, okay, it's Monday morning. Will I make it to lunch? To say that there are a lot of cases going on is unfortunately true. I think it's getting reported better than it was 10 or 15 years ago, or I should say reported more often. I wouldn't say that it's necessarily an increase in the frequency. It's just an increase in the awareness and people wanting to take action about it. So it is, there's a lot. There's no other way to sugarcoat it. There's more than you'd want there to be.
If I could follow up the question, do you have any actual data? I mean, do you not track this on a year-by-year basis? Is that available data?
Madam Chair, there's a report that we give to the state board every year, kind of summarizing the number of cases. I don't have that in front of me. I'd be happy to provide it. I don't think we've put together the 2023 data yet, but there is something I usually put together and give to the state board. And I will say that the vast majority of those cases are based on criminal convictions. Not all of them, but most of those are based on criminal convictions. So I don't have to retry the case. They pled guilty and they're done with it.
All right, thank you. I think that would be a very helpful report to see.
Is that a report that you can provide to the committee at a later date?
Yes, I'd be happy to send that too.
Thank you. Are there other questions? I do have a question specifically regarding this 91-22-1A 4. You seem to be enacting a regulation regarding, as you've described it, and as it's written, inappropriate and overly personal and intimate relationship with a student. And you have mentioned, you've said it's the anti-grooming regulation, and you've talked about grooming a student for sexual relations with that student. And we hear in the news that there's other types of grooming as well for students regarding sex changes and gender identity and things like that. Does this proposed regulation address any of that type of conduct?
No, not at all. In fact, that's exactly why we do not use the word grooming. That was one of the big things that was here's the thing. Grooming has become such a political term and it's been used for other circumstances. That's why I don't use the word grooming in the regulation, but that's not what that's talking about. And that's actually, we specifically did not want to require proof that it was going to be sexual in subpart 4. So I may have referenced that as generally being what the concern is, but that's not what's written in the regulation.
And that was a policy decision of the Board of Education, correct? To write it this way versus another way?
That's correct.
And you're only then talking about sexual relations with a student in this subsection 4.
Not necessarily. I don't have to. Here's the issue. There's a federal definition, and I forget exactly what it is it defines, that basically requires you to prove that there's sexual conduct. Candidly, if I have to wait until they've actually had the sexual conduct, it defeats the purpose. I can't tell you how many students and adults have come forward and said, please do something about this. I was groomed by my teacher. Nobody did anything about it because we kept hiding and I kept lying about whether or not we were having sex. Everyone knew, but they couldn't prove we were actually having sex until years later because I would never admit it. They said, you've got to do something about this. And that is why 4 is written the way that it is.
Well, I agree that we shouldn't have to wait until there are actually sexual relations between the teacher and the student. So it's steps need to be taken, but as Senator Tyson mentioned, this sounds like a policy decision and not just a rules and regulation that maybe should be something brought to the legislature. But are there any other questions? I'm not seeing any then, so go ahead and proceed.
The rest of this really isn't much of a change. I would tell you that we did add the language engaging in conduct that results in substantiated findings of abuse by the Kansas Department for Children and Families. I appeared before this committee years ago, and at that time, members of the committee were disappointed that we had not acted faster to close a loophole that we did not have something specific in regulation that if you have someone that is prohibited, for example, from working in the daycare facility because they've had a substantiated finding of child abuse, why are we not doing anything to stop that person from essentially teaching in the schools? So that's kind of our fix there. We're trying to close that loophole. We already have that kind of a waiver and a disclosure on the applications for a license, pardon me, that by applying for a license, you are giving us consent to find out if you're on the registry. And for what it's worth, in case there are concerns, we do not take every allegation or a substantiated finding of child abuse to the state board. In fact, there's a very small, I don't want to say small, there are plenty of cases we look at and we realize, okay, there was substantiated finding 15, 10, 20 years ago, but that person has been teaching for 10 or more years since then. There may be a circumstance we decide not to take that case as a licensure. We just put that in there, we kind of codify it, if you will, so that everyone is on notice that if you have a substantiated finding, that may affect your ability to get a license. That was actually a request that was given to us by attorneys that represent teachers, that the teacher said, if I had known this might affect my ability to get a license down the road, I would have contested it at the time, but I didn't think it really mattered. So that's why we're putting the language in the regulation.
And what section was that?
I'm down on number 6 on page 2.
And if engaging in conduct was so old, you were saying 15 years, 20 years ago, then it would be considered by the Board of Education to no longer be relevant to their current standing to be licensed by the State Board of Education. Potentially, if they don't have any current or more recent.
Just like any other allegation, it depends on the recency. How recent were these allegations and how recent was the conduct, and is there some kind of a pattern? Those are the things we most likely look at determining whether or not this is someone we need to look closely at before we issue a license.
And why is recency so important? And if it's in the distant past, it's not so relevant.
You give people, there is an argument to be made. And there are people that have actually testified. I think that's why 74-120 was passed when it did, was people have the opportunity and the right to prove rehabilitation, to prove they're not the same person they were 20 years ago. And so I'm not, again, if you were abused of like really hurting children 20 years ago, yeah, we're going to take that case to the state board. If it's an allegation of you were a 19 or a 20-year-old and you were in charge of supervising younger siblings or a child and you failed to supervise them appropriately, and now you're applying for a teaching license and you're 38, 39 years old, you've already been through a teacher prep program, yeah, we may not take that case before. That may not be a licensing issue.
Senator Tyson.
Thank you, Madam Chairman. Will you please define current?
I don't have a set bride. We say current.
Well, you said that if it's not current or recent, and
Right.
That's why I think this needs to be vetted before the legislature. There are so many subjective innuendos, and could be interpreted one way by any individual. I just think it needs fully vetted by the legislature. I would hope that you would reconsider these rules and regulations. And it's quite disappointing that the State Board of Education would bring this before us at this time in this manner.
Representative Penn.
Thank you, Madam Chair. And thank you for standing before us today. That takes courage. So I appreciate you being here, especially with this flaming hot mess that you brought before us. It takes extreme courage. You just said if someone is, how you doing, Senator? If someone is convicted or accused of really hurting a child, it goes to Senator Tyson's point. The subjectiveness in that language
what is really real rape? What is really hurting a child? If someone in their history, in their past, has done anything to harm, to disrupt, to abuse a child, no matter the amount, no matter the intensity, no matter the thrust of it, that child lives with those indelible scars. I've had constituents reach out to me in the past couple of weeks. They are accused of doing the very things that you seem to, in this proposal, to allow to let slide. They are stand accused by the children who have now grown up, and that thing has hit them in counseling. And now they are looking at their life in shambles, trying to understand what in the world happened. But you're telling me that it's okay for the state of Kansas to license people to be in charge of children, do that type of damage to them that may not show up for years hence, but it's okay because it's not really harming a child. I agree with my colleagues and the senators as well. This needs to go before the people's elected representatives to hash it out. This is not something that should be left in the hands, because I do want to ask a serious question here. How do you define indecent liberties with a child?
Madam Chair, if I may, that's defined in state statute as a crime.
Exactly, it's a crime. Those indecent liberties with the child, as you were talking about the words and the terms that you want to avoid, is grooming. And I think there's a reason that you're running to the shadows and the gray areas on your terminology. I'll say it for everybody. To come into a space and tell a child and have a teacher influence a child to talk about their sexual orientation, their gender identity, and influence them to go one way or another is not the appropriate space for any teacher. It is not. Because it is predicated upon that teacher going into a sexual conversation with a minor. That is not their child. So I would love to understand how it is in this proposal that you handle those teachers that would go and take those indecent liberties with the child and groom them, your word, not mine, into pursuing a sexual orientation, a gender identity change, a surgery, or a chemical castration to support that. All of those types of things you leave wide open here. Do not address it, will not address it. Again, your words, not mine. And I find it wholly lacking. And as I said, a flaming hot mess that takes extreme courage to come before us and actually give this proposal. This needs to come to the legislature. This needs to be aired out. Thank you, Madam Chair.
Thank you, Representative.
Madam Chair, if I may.
Sure.
Sorry, respectfully, Representative, everything you described, and it's been a long time since I prosecuted crimes, but I did prosecute sex crimes for 4 years, 3.5 years. Indecent liberties, that's not what the definition of, that's not what the crime of indecent liberties is with a child. Talking to them, but that's just not what that crime is. As far as the other issues, I understand the concerns that you have. This set of regulations we started in 2017, 2018.
Excuse me, Madam Chair.
Just a moment. He's replying.
So anyway,
give him a chance.
To your point, what I've been sharing with you is the discretion that the department takes before we decide whether to file a complaint or not. The regulations, the language that I'm sharing with you, functionally isn't changing the practices. We're just putting more people on notice on the basis for which a complaint could be filed. The statute that was passed, 74-120, specifically required us to revise and renew our regulations so that we could not use general language like misconduct or other just cause. So that's what this effort is to clarify these are the solid reasons by which we may deny someone a teaching license so that we can't rely on just generic terms. I think, well, I won't go. Thank you, Madam Chair. I think I've answered to the extent that there was a question there. I think that I've answered it. So
I think so. Thank you. If there aren't any further questions, we can proceed.
The question did come up, and I believe Representative Wassinger, I think this may have been your question. I'm now on page 3, going down to subpoint B, where any individual with a criminal or civil record described. Is this what your question pertained to, Representative? Thank you, Madam. 74-120 specifically authorizes, and we were advised by the Office of the Attorney General as we were revising the regulations, you should really put language to this effect in the regulations so that you're in compliance with the state law. What this allows is if someone has something in their criminal history and they want to know before they go through this whole process, they want to find out, look, I was convicted of this crime 8 years ago. If I'm not going to get a teaching license, then I don't want to spend 4 years in college getting a teaching degree. So can you give me a heads up of am I going to be denied a license? Like, that's my understanding of why that statute was passed, and the regulation here models the same exact language in the statute. That $50 fee, in all candor, we've never charged it. If people call me all the time asking, look, I've got an applicant, I've got a teacher, they've got this conviction from 12 years ago, is that going to stop them? And I'll share with them, well, here's the statute that says thou shalt not be licensed ever if you've ever been convicted of these. And it also lists a certain level of felonies and misdemeanors that if you have ever been convicted or placed on diversion for these offenses, you might not get a license. The state board has to make a determination, and it lays out the factors the board has to consider. Right? And then we have those in regulation also. So we share that. That language is added at the request of the Attorney General's office to make sure we were in compliance with 74-120.
Which language was added, you said?
This was all of the underlying language in, I'm looking at, it's 22-1A-B, starting with any individual with a criminal or civil record described in this regulation may submit a petition.
Okay, that first sentence there of
that B and B, little 1, 2, and 3 under that, that's all new language that is repetitive of that statute.
And does the revisor know, do we have such a process in place for other types of licenses in Kansas?
Thank you, Madam Chair. So in 2018, the legislature passed, as Scott mentioned, 74-120, and that did require an agency, with the exception of a few, to allow for this process. You may have remembered about 2020, we had some other agencies come through, rules and regs to go through this, went through actual statutes to pass to allow this, but it would be the vast majority of agencies and boards and commissions would be subject to the provisions in 74-120 that would allow this procedure, whether or not they've actually adopted it or not.
Okay, and that was passed in 2020, you said?
The legislation 74-120 was passed in 2018, and it gave agencies within 180 days to implement the requirements. But it does not apply to some agencies, specifically the Board of Healing Arts, does not relate to attorneys, law enforcement, things like that.
Okay, so a little late from the Board of Education if it was 180 days passed in 2018, and here we are in 2024, if I'm listening to the chronology correctly. But a couple years late, but go ahead and proceed.
Madam Chair, for what it's worth, we've been working on these since before that bill ever was introduced. Yes, it's taken a very long time to get here. That much is.
Well, it doesn't seem that complicated here. So just curious about why it took so long.
At least 8 different attorneys with the Attorney General's office has reviewed it, and now 2 revisors from the Department of Administration.
That's why it took so long? That's why?
Yes. Sorry, Madam Chair. Yes, I've been working on these, trying to get them approved for 6 years from those 2 offices. We had 2 attorneys that were fine with the language. Then 74-120 got passed. So we had to take everything back. Those 2 understood, yeah, no, we think we're still good with that. Those 2 attorneys left that office, or they weren't in that division anymore. They had 2 or 3 others come in to review them. They changed their mind. I came back to the legislature asking for the state board to be exempt, just like half the other state agencies that are exempt on the bill. I think I tried that twice, and it never went anywhere. In that process, we continued to work with the Office of the Attorney General to make the regulations come into place. Then we had a new Attorney General come in, new staff. now we've been able to get to this point.
Thank you. Senator Tyson.
Thank you, Madam Chairman. I actually have a question for the revisers. So since they put these in the same packet and we've asked them to withdraw, it looks like a political ploy. They've got rules and regs that they need to get through that they should have gotten through years ago, and they wait until they have a controversial topic to attempt to push it through at the same time. Can these be split up, or would they have to start the process over? And I think I know the answer. What does it look like?
Thank you, Madam Chair. If we look to the requirements of the Rules and Regulations Filing Act, the agency would have discretion if it wished to not adopt one particular regulation or not. When it goes through the process, you may notice different date stamps on different specific regulations. So when they go through the Attorney General's office or the Department of Administration process, those agencies could approve one regulation and not approve others.
Thank you. And I want to be clear, it's important that the board do put in place, for instance, this procedure for our prospective teachers so that they are aware if they're going to be pursuing an education along those lines and then ultimately to be denied, that would be helpful for Kansans looking at that. But maybe there's a lot of questions about the process as you've heard here today. But go ahead and proceed unless we have other questions.
And again, for what it's worth, if I may, Madam Chair, everything that's described in B that was required by statute, that's always been an option. I don't think I've ever denied anyone to be able to ask me if they could get a license or not. That's not new. It's just we've put the specific process that the statute asks for. Going to page 4, this does just clarify some of the timelines, and there's some language that's clarified there. I don't think that there's anything substantive because a lot of that was moved to 1B, but I'm happy to answer any questions if I've missed something there. The page 5 does lay out the specific factors that the state board will consider whenever they are reviewing an application for a license. Those are the factors that are basically the elements of rehabilitation, if you will, the state board considers. It kind of puts everybody on notice. When you appear before us, this is what we want to know. I don't think those have changed in 20 years. The language has changed a little bit, but not much. The next page clarifies the kind of the timeline and when someone becomes eligible to be licensed, if they have had a license denied or if they've engaged in the conduct. We clarify because right now, if you are convicted of any of the offenses that I've described, then you're not eligible to be licensed for 5 years from either the date of the conviction or the occurrence. So the question always comes up, well, if I get convicted of something that I did a year and a half ago, when does the clock start? So we've clarified that. We've also clarified that if there is no conviction, then it is a year from the time that we find out the offense occurred. So if it's a felony, we leave that as 5 years, have elapsed from the date of the conviction, because that is also what's written in statute. If you are convicted of one of the misdemeanors that's been listed, it's either 1 year from the date of the conviction or if you've completed probation, whatever's later. So if it's a 2-year probation, you have to come off probation before you're eligible to receive a license. The criminal diversion, this was probably one of this was a long point of discussion. There's another separate state statute, the one that's listed there, 2165B, that lists certain offenses for which the state board is prohibited from issuing someone a license if they've been on a diversion for that list of crimes. Rather than list them, we just refer to the statute. And so if they have entered into a criminal diversion for any of those offenses, which essentially are felonies, most of them are felonies. I can't think of any misdemeanors off the top of my head, but I think they're all felonies. Then you have to complete satisfy the terms and conditions of the diversion. So once you're off diversion, you would be eligible. If there is no conviction or no diversion, then it's 1 year from the date of the offense that you engaged in. That is when you'd be eligible to receive your license. Again, that was clarifying language that was actually requested by teachers and by the Professional Practices Commission because they wanted to be consistent and they wanted to put everybody on notice. Madam Chair, if you're ready, I'll go on to B, which is by and large the same stuff. Those are the basis by which a license may be denied or pardon me, not denied, but if a licensee will be revoked, suspended, or censured. Yes, ma'am.
Thank you. Committee, are there any questions on 91-22-1A before we leave it and move on to 1B? Any further questions, I should say? I'm not seeing any, so go ahead and proceed. Thank you.
Again, that first page is all the same things we've already covered. Under 1A, it just clarifies those are the same basis by which a license may be disciplined. It does clarify that a certified copy of a journal entry of a conviction or otherwise proving that someone has been found guilty of something, that's essentially the only evidence that I need. If I'm relying strictly on a conviction, then that's the only evidence that I need, and that is the evidence that I would need to prove the conviction occurred. Again, I'm happy to answer any questions on this. If there's any questions about B, it seems like we've probably already covered most of it. Moving to.
So the only change to B is it's brand new. Okay, any questions? Okay, go ahead and proceed.
So 22.2 outlines the actual process of the Professional Practice Commission. We just need a simple majority. Here's the biggest difference in the way the regulation is written. Even since before I got here, the process has been that whoever represents the department essentially, if you will, acts as the prosecutor. Like, so we would bring the case forward and the Professional Practices Commission would act as judge and jury to make the recommendation to the state board. The way that it was originally written, and again, I don't know why this was, the person in my position would take it to the PPC, take the allegations to the Professional Practices Commission. And the Professional Practices Commission was then supposed to make the determination whether to move forward. But that wasn't how the practice was before I started. And I would tell you, having the criminal prosecuting background, I had grave concerns about the entity that's acting as judge and jury, seeing the allegations ahead of time before the person ever had the opportunity to take part in it. So we've never done it that way. So the language in 22.2 is just to clarify that the commission's secretary shall keep an accurate file of all votes, official acts, and proceedings. That's someone we have in the office that acts as the secretary on behalf of the PPC. So the chairperson gets notified whenever we do file a complaint, but it's the same time and the same way that the respondent or the licensee or the applicant would receive notification.
Is this then an effort to provide more due process, more fairness to the respondent?
That is 100% why we have that practice.
To be aware of and kept track of how complaints are handled and allegations made, and providing more fairness to the respondent.
That's right.
Thank you.
The next is the complaint, and this is, again, really the only changes in 22.5A, in my opinion. Grammatically, it changes a few things. Instead of verifying, it can either be sworn to or it can be accompanied by an affidavit attesting to the veracity. The current language requires that all documents in my possession or the complainant's possession have to be attached and are a part of the complaint. The concern is that many times we will have written statements from students or other minors, or they will be statements that include information about minors, and complaints are public records. I don't like the idea of having those documents specifically attached to the complaints. So what we have done is we just reference them in the complaint. And as soon as someone asks for a hearing, or if they ask to see, well, what is this document? And I will tell you 95% of the time we're talking about court documents. Like the licensee already knows these documents exist. If they want to see our version of them, we turn them over as soon as they say, I don't know what you're talking about as far as a conviction goes. So we provide those. Same thing goes with the other written documents. It's just kind of part of the normal discovery process. I keep an open file philosophy that if I'm accusing you of something, you get to see everything in my file that I'm relying on for that accusation. So that's just clarifying.
And in the criminal context, that's part of your constitutional right to confront the witnesses against you and in a timely way, and an opportunity to be heard as the respondent. Because, I mean, we want, and I think we're required by law to be fair to both sides. So, thank you.
That's why those changes have been made, for that exact reason.
Thank you.
And then on the second page, sorry, unless there's a question, I'm going to page 2 of 5A. A difference here is up till now, everything has to go before the Professional Practices Commission before it goes to the state board. We have a lot of default cases where someone doesn't bother responding to the complaint, either because candidly, there are times that they move and they don't tell us they've moved. So I don't know, we try to mail it to the last known address, they don't respond. Or they are in prison because they've been convicted of sex offenses. That happens. Sometimes we get responses from those individuals, sometimes we don't. Usually we don't. Or the person just says, okay, yeah, you caught me, you found out about those convictions, I didn't know you knew about that. I don't want my license that bad. In those cases, it being a default, the Professional Practices Commission has asked, why don't you just take those straight to the state board? And so the change is, if we decided something that doesn't need to go to the PPC, just to rubber stamp it, then those can go straight to the state board. And that's also true of, I do the line through surrender of a license, but all of the surrenders of a license are essentially treated as default cases also. If someone surrenders a license, they never show up to say, I surrender. They always do it in writing. I'm happy to answer any questions before I move on to 22.9 if there are any. I apologize. I think I may have jumped ahead a little bit talking about the default process that's actually laid out clear in 22.9. We did clarify. So in the Administrative Procedures Act, an individual that has a complaint filed against them has 15 days to ask for a hearing. Again, 23 years ago, or whenever these regulations were first written, I don't think CAPA was even around at the time. The individual had 20 days. So rather than have two different deadlines, we just changed it to, you've got 15 days to send in your answer or ask for a hearing. It doesn't take a lot, by the way, to ask for a hearing. Literally just an email saying, I want my license, please give me a hearing. Okay, we schedule you for a hearing. If you file any kind of an answer other than, yes, I did it, you caught me, I don't want my license. If it's anything but that, we schedule for hearing. We do require them to submit it by certified mail return receipt. Because we want proof, we want to give them the opportunity to prove they actually mailed it to us on a timely manner. And then there's the default findings that's explained in the second paragraph there. Nothing else really changed except for a few grammatical changes on 5. Are there any questions there?
Was that on 5A?
Yes, ma'am. Yes, Madam Chair. Pardon me. No, that was 9. I'm sorry. I skipped. I was explaining 9. I apologize.
Okay, thank you. So that didn't look like 5A. Thank you.
Moving on to 2222, the actual hearing procedure. This was the clarification I attempted to give earlier, that default, we follow the statutes in the Kansas Administrative Procedures Act. If there are certain things that are different or clarified in the regulations that conflict with the Administrative Procedures Act, then we follow these regulations. It does explain that instead of any person having a substantial interest in the outcome, we changed that to each party to a complaint. Candidly, I had no idea what a person having a substantial interest in the outcome meant. If there's a school district, for example, that's not involved in the case, we didn't feel like they had the opportunity to ask for a continuance because it's not their case. So we clarified that just by sending written motion. And I think that was the only change made in 2222. Moving to 2225, those are just some grammatical changes as far as the decision of the commission. The commission may do one of 4 different things. They may decide to recommend imposing no discipline. They may decide if it is based on an allegation of breach of contract. That is the only time that the PPC may dismiss the case outright and it doesn't go to the state board. And again, that is because in statute and in other regulations that we don't touch here, if there is a buyout provision or a liquidated damages clause in the contract, that is the school district's only remedy. So if the PPC, and I will tell you candidly, if the hearing officer reviews the facts that are given to him, all the documents, mainly a contract, and finds there's a liquidated damages clause, the complaint gets dismissed. And it doesn't even proceed to hearing at that point. Or they may recommend denial, suspension, or revocation of a license, or they may recommend public censure of the respondent. People ask me all the time, what does it mean to be publicly censured? That is a one-time written, you have a final order that says the state board hereby censures you for your conduct. The censure occurs anytime the state board wants to acknowledge that someone engaged in professional misconduct, but it does not rise to the level to take that person out of the classroom. So that's what a public censure is. Nothing goes on the actual license itself. It doesn't stop the person from being licensed. It really honestly doesn't affect the status of their license. It just kind of, I don't like saying slap on the hand, but it is essentially a one-time written slap on the hand saying, you did bad, don't do it again, type thing. And that, Madam Chair, is the set of regulations. I'm happy to answer any questions.
Thank you, Representative Wassinger.
Not being an attorney, just wanted to ask this question. If you are publicly censured, does it remain in the record of the state so if something else comes up, they know that this has been done? Or put in their permanent file, like they used to say in school? You don't want that in your permanent file.
Thank you, Madam Chair. Yes, the fear of the permanent file always followed me around as well. For what it's worth, yes, everything that my office looks into, and I've got files that are 30 years old, we keep all of that. So if there's ever an allegation that somebody did something today, if I look back and go, look, you were told 20 years ago to not do this, or there's a pattern here, right? So that's always going to be in our files, even if the state board does not impose any kind of discipline. The censure does remain. I mean, it's a public record. All the disciplinary actions of the state board are published on the agency website. All of the disciplinary actions are also sent out and shared with every superintendent in the state. They go out on a listserv, and just to let them know, by the way, this is an action we took and this is why we took it. It's also indicated on a national clearinghouse, so that if someone leaves Kansas and they want to be licensed in another state, that other state can look in this database and say, oh, Kansas censured this person for whatever this conduct is. I'd like more information about this, so they know. Again, it doesn't necessarily mean they're not going to get licensed in that next state. It just kind of puts everybody on notice.
Okay. Thank you, Madam Chair.
Thank you, Senator Francisco. We can't hear you, Senator.
Thank you so much. I just want to say I appreciate the review of these regulations, and I am comfortable with what is being proposed. I believe if the committee as a whole has any objections to any of these, that we should have that discussion and decide if we want to file a bill to change any of this in statute. But otherwise, I would be very comfortable.
Thank you. You talked about if there are liquidated damages provisions in the contract for the particular complaint, that the complaint then is dismissed. So you don't have to prove the allegations of the complaint to then get to the remedy of liquidated damages, or I didn't understand your statement about that.
So that only applies to allegations of breach of contract.
I understand, but you still have to prove the breach, don't you? Or you're saying the breach then is going to be heard outside of the board?
Pardon me, Madam Chair. So, and this is all candor, this is why my office doesn't investigate these, doesn't take care of these. I don't want to be responsible for interpreting the school district's contract, and they don't want me responsible for interpreting their contract. So if there's a breach of contract, there's a civil remedy available that the school district can engage in.
So you're kind of asserting you don't have jurisdiction to hear it and
That's
it'll be heard over there.
If you put in the contract, it's kind of a, and I would tell you, my understanding is a lot of school districts have taken their liquidated damages clauses out. You know, they decided that a damage clause of, okay, fine, if you pay $1,000 liquidated damages clause to help cover the cost of substitutes to make up for the fact that you're not going to be in the classroom, we'll call it good. I mean, that was a kind of a common clause in teaching license. School districts have found that's not enough money to cover because there is such a teacher shortage. There's a shortage of substitutes. So many times they've taken those clauses out, but sometimes they do still exist. And frankly, if you negotiate this remedy in your contract, then you're bound to that remedy as part of that contract. That goes for the teachers as well as the school districts.
And is one form of discipline moving a teacher to another school building within the school district?
Not at the licensure level. That would be an employment issue.
Okay, but
We have
not
absolutely
handled through
no
licensure.
say over teacher placement, assignment.
Okay.
Yeah, no, that would not be something the state board could do.
Thank you. Then I don't see any other questions. Then thank you for your testimony today and presenting these regulations to the board, or excuse me, to the committee today, and for your testimony. Appreciate it. Thank you. With that committee, then we will move on to the Kansas Department of Wildlife and Parks and invite Dan Riley, Chief Counsel, to the podium. Please introduce yourself and welcome to committee.
Good morning, Madam Chair. I am Dan Riley, Chief Counsel from Wildlife and Parks. With me this morning is Captain Eric Denault, who is our technical expert on boating safety and boating law, since we have one regulation today that involves flotation devices. We had 3 regulations before the committee this morning. The first one is KR 115-4-11, and this is the regulation that deals with all big game and turkey permits. The changes that we've got before the committee this morning specifically deal with antelope. And in the antelope information, they specifically deal with the preference point system. And all we're doing here is trying to clarify language that has always been cumbersome and awkward and difficult for people to interpret. The preference point system basically is a point that's it's kind of a participation point. If you participate in the antelope draw and you don't draw a tag, you still are awarded a preference point, which gives you a preference for the next time you participate in the process. So it's kind of a consolation prize. And it was developed originally by the state of Colorado, I believe, to kind of appease hunters that weren't successful in terms of the draw. And it's beneficial for that purpose. And it kind of evolved to the point where you can also purchase a preference point if you choose not to hunt for a year to improve your stead when you do re-enter the draw. So that's just generally speaking what the preference point system is for. The first change is on page 3 of the regulation. And that basically is just a clarification that the preference point is only applicable in a draw where there are limited permits, which basically means if the demand is greater than the number, then the preference points are available. The next change is on page 4. Again, it's just a clarification in terms of when the preference process is available. And like I say, this section has always been cumbersome and awkward, and I think we've got a pretty good handle now on clarifying the language so it makes sense in terms of the process. In section 5, again, just clarification in terms of language that was kind of redundant and awkward and didn't make it easy to understand exactly how the preference point process applied. Are there any questions on any of these changes?
Thank you. Committee, any questions? Not seeing any. Go ahead.
Great. And basically, if you turn on over to the next page, page 5, more clarifications and one change that we're making in our effort to try to find more durable language. because we have many annual season regulations, and that's why you have to see me up here so often, because we have regulations that basically run on an annual cycle, and we're looking for ways to develop language so we don't have to renew those regulations every year. So the first change on page 5 is one of those where we attempt to come up with durable language so this regulation will be applicable this year and next year and in succeeding years, so you won't have to see so much of me. Any questions about that? You've seen some of those durable language examples before where we're trying to get away from disposable regulations, basically.
One quick question, sir. Representative Wassinger.
Thanks for being here, and thank you, Madam Chair. I'm sorry, I should have asked when you came back. The thing that just was a little bit alarming, how much does it cost to buy an extra preference point?
A preference point, I looked it up and I have to find where I wrote it down. Can't find what. I will answer if you will allow me to. I will look it up when I get back in my office, and I'll send you the answer because I know I looked it up and wrote it down, but I can't find where I put it in my notes.
I appreciate that because the only issue I see with that is if you have more money, you can get more preference points. And then that means you've got winners or losers in this lottery.
Well, there's a limit. You can only purchase one a year, so you can't buy an unlimited number.
And they expire.
Correct.
Okay, if you could find out what that price is.
I will do that. And I may find it before I leave today because I know I wrote it down in my notes someplace. I can't lay my hands on it.
All right, thank you, sir. Thank you, Madam Chair.
Representative Penn.
Thank you, Madam Chair. And on that same point, if someone is only allowed to buy one preference point a year, can they assume or buy someone else's or get a credit from someone else?
No, they're not. They're
trackable to a single individual.
Correct. And if you purchase any other tag in the antelope hunting system draw, then you can't. It's basically a one on. Yeah. If you purchase another permit, you're not eligible to purchase a preference point. $10. Thank you. I'm not used to having help. I really appreciate that. Yeah. Any other? That's pretty much the first reg, the 115.411. Any other questions on that one? The next regulation that we've got before you today is 115.2511. And this one deals with fur bearers and open seasons. And primarily here, we're making some of the same kind of changes in terms of clarification and also durable language to try to make it so we don't have to come back in and change this regulation every year. The first change on page 1 is something that was recommended to us by the Attorney General's office in terms of the actual succinct legal definition for the closure of a season at the end of the day. So the technically correct language is not 12 o'clock midnight, we learned. It's 11:59 p.m. So that's the reason for that change. The second change on the first page in section C basically is one of durable language, where we find a way to describe the beginning and end of the season that doesn't have to be reset every year. Likewise, on the other changes that you see coming down through the first page, basically making the same changes for the other species of fur bearers is all that those changes are making. And in the last section, section E, which is on page 2, a clarification in the language there that reestablishes the beginning and end of the running season with the durable language, so it doesn't have to be reset every year. Are there any questions on any of those changes?
Not seeing any. Oh, one quick one. Representative Wassinger.
I like those numbers. How many hunters do we have doing this in the state? And are there out-of-state hunters that come in for the otters, raccoons, etc.?
Well, they can. There's a non-resident permit available. What we assume is that will be probably 2,500 additional fur bearer licenses. And that's kind of a difficult to gauge assumption, but a lot of the changes in the fur bearer regulations of late have been due to the explosion in the raccoon population. Raccoons have exponentially reproduced, and they're causing all sorts of problems from a residential standpoint to a wildlife standpoint. They're predatory. They eat ground nesting bird eggs. So they damage turkeys, they damage quail, they damage pheasants. And many of these changes were prompted by that. And it's kind of contemplated that the predator control business is going to expand also as a result, first of all, the increasing size of the problem, but also the expanded time frame in which to do it. So this is largely in response to the raccoon problem.
Thank you, Madam Chair. That was really what I was looking for.
You bet. The final regulation that we have before you today deals with flotation devices. The Coast Guard is the primary authority in terms of boating safety devices such as flotation devices. And they are revamping their standards in terms of identification for flotation devices. And all we are doing is changing our regulation to correspond with that. And the new Coast Guard set of standards looks like a pretty significant improvement. First of all, it's going to standardize the American and the Canadian. So before there were two sets of standards. So this unifies that. It also kind of clarifies what the ratings for the devices will be based on buoyancy. The old system used numbers that didn't really have any correlation. The highest category of flotation device was a 1, but the 2s and the 3s and the 4s didn't really relate in a linear way to that. Now the performance levels will be a 50, a 70, a 150, or 275, and that's actually based on buoyancy. And the devices will also have indications on them what type of water activity that they're intended for. Something that's intended to be for a canoe or a kayaker is going to require that it have additional straps and buckles as opposed to the simple kind of horse collar, just get a life jacket on somebody kind of a category 50. So I think it'll be an improvement. As I say, Captain Denault is with me today. So if you have any specific questions about this change or any water safety issues, he's available for that. But that's basically the purpose of that change in the reg.
Thank you. Committee, any questions? I'm not.
And this will not make the current jackets that were approved obsolete. You don't have to throw away what you have to be in compliance. So it doesn't make them no longer compliant.
So it just regulates the purchasing of new or the new requirements?
The Coast Guard basically is just the manufacturer is going to start manufacturing to the standard, and their intent is that eventually the old ones will just be replaced by new ones. So,
but it doesn't by regulation make the old ones obsolete
no.
or non-compliant. Okay. Committee, any questions? I'm not seeing any. So thank you, sir, for your testimony today and presenting these to committee. We will then try to be moving back on track with our timetable, but we've had a lot of good discussion today. Next, we will hear from the Kansas Corporation Commission, Ahsan Latif Litigation Counsel.
Good morning, Chair and committee members. I'm Ahsan Latif. I'm litigation counsel for the Kansas Corporation Commission, and today I am representing the Transportation Division of the KCC. And we have 3 regulations for you to review. The KCC is the state agency charged with implementing rules and regulations relevant to motor carrier operations, so commercial motor vehicles that are over 10,000 pounds that operate in commerce. And the regulations, before you provide updates that will help us with uniformity of enforcement, the Kansas motor carriers don't generally just operate in Kansas. They cross state lines and operate in other states. And so the motor carriers have and drivers have the understanding that they're subject to the same rules in each state. There are federal rules promulgated by the Federal Motor Carrier Safety Administration that apply to them. Generally, in Kansas, we try to adopt those same uniform rules where we can, so that the experience of Kansas motor carriers is the same as in other states. So we have 3 changes before you today. The first one is in KAR. All 3 of our changes have to do with updating to documents that change that we adopt, and so we're trying to update to the latest documents that we reference in those regulations. And KAR 8241, this regulation, it defines the terms that we use in the motor carrier safety regulations. And among those terms is a term for out of service, or OOS, which is the designation that law enforcement gives to motor carriers who are found to be at roadside having major violations. And this definition is, there's a reference document and a guideline document called the North American Out of Service Criteria that's updated annually. And so this updates to the 2023 version of that document, which is the latest version.
Out of service doesn't mean you're pulled over on the side of the road because you've got a flat tire or
So
what is.
the commercial motor vehicles are inspected by Kansas Highway Patrol when they're at roadside, and they can be stopped, and they can be they go through and check your safety and see what to make sure that you're operating safely. An out of service violation would be a flat tire, taillights that are not working. The driver doesn't have a CDL and he's driving a CDL required vehicle. And those go in more specific detail in the North American Out of Service Criteria.
So it would apply to someone says has ceased to operate or move. So that means.
Yeah, if you are out of service, then you have to correct the violation before you can continue operating.
Okay. Go ahead.
The next regulation is KAR 8243J. This regulation adopts a portion of the federal regulation that govern inspection, repair, and maintenance of commercial motor vehicles. These are guidelines that a motor carrier has to have to comply with to operate safely on the roads. The change here is that previously the requirements for an annual inspection were under Appendix G, and that has been moved to Appendix A. And so the forms that they use to fill out the annual inspections now say Appendix A instead of G. And so to ensure that there's not confusion among motor carriers about what rules they're complying with, the Kansas Highway Patrol asked us to expedite the update of this regulation so that it refers to the correct appendix. So that's the change there.
Were those the 3 then? So.
I have one more. The KAR 82430A. So I didn't know if you wanted me to stop after each one or keep going. KAR 82430A, that is the regulation which deals with unified carrier registration fees. Unified carrier registration fees are owed by carriers that operate across state lines. When they you pay that if you operate within Kansas and you don't cross state lines, you don't have to pay interstate fees. But if you cross interstate lines, you do. And the fees are collected, they're paid for by motor carriers across the country and then redistributed back to the states to pay for safety programs. Kansas has the highest level of UCR compliance in the country, in North America, with 99% of carriers paying their UCR fees. And this puts them at an advantage when they're crossing the country, because if they're inspected in another state, they're not found to be deficient in paying their UCR fees, so they don't get a fine in another state. They're already compliant. This change that we're proposing here updates the fee schedule to the 2024 fee schedule, which is reduced from the previous year. The UCR fees, as more and more motor carriers are operating and more pay into the fund, the fees have gone down consecutively each year. From, I think 3 years ago, it was $59 for a single operator, to now $37 is the current fee for operating interstate.
Thank you. Any questions? I'm not seeing, I see one. Representative Wassinger.
It's not a question, it's a comment. It's very unusual for us to hear that you have lowered the fees on anything. So I appreciate that. Thank you, Madam Chair.
Thank you. And it's kind of timely, the first regulation you bring, the out of service, because I believe there is a proposed a bill this session that would talk about if you are a not an emergency vehicle, but you're another type of vehicle pulled over on the side of the road, that would require motorists to move over to give clearance for that stopped vehicle on the side of the road for safety purposes for the stopped vehicle. And when this OOS applies to you have ceased to move, maybe you are one of those commercial vehicles stopped on the side of the road and want to give you clearance so that the driver or other occupants of that vehicle remain safe while dealing with their immediate circumstances. So I think we'll be hearing more about this session. But thank you. Thank you for your testimony today. Appreciate you appearing in front of committee. Thank you. Committee, we will then be hearing from the Department of Revenue, Taylor Murray, attorney. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, committee members. I'm Taylor Murray from the Office of Policy and Research with the Department of Revenue. First, I want to thank the committee for considering these regulations. So these are two proposed new regulations to help with the administration of a tax credit created by 2023 Senate Bill 123. That contained the adult learner grant, which you heard explained earlier in this meeting. So these are part of the credit that goes along with for the recipients of that grant. The tax credit was in new Section 7 of the bill, which was enacted as KSA 74-32-287. That includes subsection D, which directs the Secretary of Revenue to adopt rules and regulations to administer the credit. Quoting from the statute, such rules and regulations shall include criteria to determine whether an individual who has received a Kansas Adult Learner Grant has fulfilled the requirements to receive a tax credit. So today, before you, we have KR 9212-150. This provides definitions to help us administer the credit, and KR 9212-151. This establishes that one graduation equals one credit. So clarifying that this is a one-time credit, it must be claimed according to the limitation in the statute not later than the 5th taxable year after the taxable year in which the individual completes their degree. And the public hearing for these is February 27th, 2024. We haven't received any public comments as of this date. Madam Chair, I'm happy to explain whatever you'd like or stand for questions.
Thank you. Committee, any questions? And these are new regulations proposed pursuant to, was Senate Bill 123?
That's correct, Madam Chair. Yeah, there's a requirement in Senate Bill 123 for these regulations.
Okay, great. Any questions? I'm not seeing any then. Thank you very much for your testimony and for appearing today here in front of the committee. Appreciate it.
Thank you again.
Thank you. We will now be hearing from Emergency Medical Services Board, Joseph House, Executive Director. Please introduce yourself and welcome to committee.
Good morning, Madam Chair. Joe House, the Executive Director of the Kansas Emergency Medical Services Board, here to present to you 10922, which is going to look very familiar because you just saw it in October. Had no issues with it there. We were a little embarrassed by this going through. We actually had a double-stamped previous version of the regulation go through the entire process. We caught it upon publication, opted to go back through the entire process with the right changes on there. So what the copy in front of you today.
Oh, make sure your microphone is on, please, or speak into it.
Speak closer. How about that?
No, we need a taller stand or something.
I have never been accused of being tall. So.
It's always nice.
Yes.
I like that too.
So what was the error prior that you're correcting and where is it?
Yeah, so version 1 ended up getting double stamped by the AG's office, went through the system itself. And so this was actually the appropriate, what's before you today is the appropriate version, what should have come through and what should have been double stamped, because the AG did request changes. We did make those on the copy that they had. It was just when they had two versions sitting next to them, they stamped the wrong one, is what it came up to. So the changes within the document that you have today, on page 1, subsection B, we added initial and renewal and reference to our online system. That was just as a terminology change there. The next change goes to page 3. Subsection E11, we changed terms, so now it shows affiliated with. We had working for there before.
Oh, just a moment. On page 2, or 109-2-2, page 1, there's a lot of changes there to the initial and renewal applications. A lot of new requirements, it seems. Just if you could just briefly describe those, just real briefly.
Absolutely. So
there's 14 new added.
Correct. Yes. So
15, I'm sorry.
And you're, yeah. So those are actually, they're stated further on within the same thing. They're just, we reorganized. This was a cleanup of this regulation to make it read much easier than what it did before. And so those actually do appear later on struck.
You're just moving them in the regulations.
Correct.
Okay, so they're not brand new to regulations. They're just new moving to this section. Okay, thank you.
And so continuing on with page 3, subsection E14, which is just 14 on there. That is new, but it is actually a statutory requirement for them to provide a description of each vehicle. That was one of the sections the AG found and said, hey, you need to reference this within the regulation as well. So we did. On page 6, we added a subsection on the renewal portion of that specific to that piece as well, just attesting to the fact that they have done exactly what they said they were going to. They haven't added any vehicles to that. The rest of the changes, the newest addition was adding subsection I to E on page 7, and it adds an odometer reading for each vehicle, and that has been practiced for 30 plus years for them to include an odometer reading as an ambulance service. It was just never listed out within the regulations, so we put it within the regulation.
Well, thank you for working to keep our emergency medical services up to date and the requirements, and keeping our equipment appropriately up to date as well. So with that, are there any questions? Not seeing any then. Thank you very much for appearing today and for your testimony. Appreciate it. No, it's okay. Committee, then, we are back on schedule, and in fact, a little bit ahead of schedule. So we now have time for a committee discussion and comments on the proposed rules and regulations we heard today. And we'll go ahead and go back to the beginning and start with the State Board of Regents. Any comments or discussions? I'm not seeing any. I think we had a few questions as part of our receiving the presentation. Do we have any comments to be included, proposed comments to be included in the minutes? Not seeing any. Then we'll move on to the State Board of Education. Same question. Any proposed comments to be submitted for the minutes? Not seeing any. So we will move on to the Kansas Department of Wildlife and Parks. No comments. So we'll move on to the Kansas Corporation Commission, Department of Revenue, and Emergency Medical Services Board. Okay. Well then, with that, we will conclude our committee discussion and comments, and want to draw the committee's attention. You might remember our last meeting, we heard from the, would it be the funeral director, the board of funeral directors? And there was a question about who could oversee or be the manager of a funeral home, if I'm remembering correctly. And there was a question about, could we hear more about funeral directors in statute and regulations? So what has been provided to each committee member and is available online as well at our website is the history of funeral director statute and regulations. So please take a look at that if you're interested, and that will probably answer the questions that we had submitted last time. So thank you for the follow-up on that. And then before we conclude, is there any other business for the committee? Yes, Representative Wassinger.
Thank you, Madam Chair. I believe we've been asking, I looked back and we were asked the Board of Optometry to report on their unencumbered funds. And I don't recall getting that. Perhaps we did, and I did not see it. And then also I have, we did somewhat talk about anesthesia assistants. We had not approved them for the state of Kansas, but they are operating in the state of Kansas, in Kansas City. And there is a loophole involved in that because apparently they can do it if they contract outside for another state that allows it, and these people come in. So I think the legislature needs to look into that as well. And then my final thing is I just wanted to alert the committee that I have filed a bill. It's 24 RS 2296 regarding the Board of Cosmetology not including sugaring in their definitions of cosmetologists, just like we did for hair threading. And I do have a personal issue with that. There's a woman in Hayes trying to develop her business of sugaring. And I was grateful to have the revisers help on that. So thank you. And that's it. That's all I have. Thank you, Madam Chair.
So do we propose comments in the minutes that we would like some follow-up from the Board of Optometry on their unencumbered funds, and any update on the anesthesia assistance, or
No,
just a comment? You just had a comment about that.
I just wanted to make sure everyone knew that even though we didn't pass that bill, they are operating in the state of Kansas. And so that's something I'm going to try to look into more. Thank you.
Maybe a legislative issue. Thank you. Representative Penn.
Thank you, Madam Chair. And Madam Vice Chair, I think that is prudent. It may be 2066 on some of the reciprocity. I don't know if legislative research can go back and take a look at the bills that we passed that allow that. But if that's something that's going on, we might want to check and see if we allow a loophole.
For the anesthesia assistance. Okay. Great. Well, I want to thank the committee members for meeting today. This is a day that's pretty quiet at the Capitol for the legislature, and we did need to get these regulations and rules heard in a timely fashion in the process. So appreciate your attention today. Our next meeting is anticipated to be February 2nd, 2024, because again, that timeline of when rules and regulations need to be heard in this committee, there's a timeline and a deadline. So keep February 2nd, 2024 kind of available on your calendar. It's another Friday. And we do have a long list, including a lot of proposed rules and regulations from the Department of Children and Families. So that would probably lead to a lot of discussion, as well as the Department of Health and Environment, the Department of Revenue, and Department for Aging and Disability Services. So there's a lot on our agenda in, what's that, about 2 weeks. So February 2nd, apologize, it's another Friday, but we will try to get you out of here so you can go home for the weekend in the afternoon. So we have the room until noon. So we will be out of here at noon. So February 2nd. So thank you all very much. And for those following along in the committee meeting room for our conferees and for those following along online. And with that, we are adjourned.